Mr. Sullivan, please raise your hand to identify yourself. Thank you.
Yes, Mr. Pitter.
May it please your lordships. It's 37 years down the line, and it's a question now, in light of all that has occurred in more recent times, for us to just consider where to begin. My lord, do you need assistance so far as the representation is concerned? I know that you already have that in mind.
Yes, well, you're with Mr. Littlehales, I think, and Mr. Atkinson, King's Counsel, is with Mr. Harris.
That's right. And, my lord, as you are aware, this is an appeal against conviction by reference, or through reference, by the CCRC.
Yes.
We have, since that time, also distilled grounds of appeal based primarily, but not solely, on fresh evidence that has emerged over the course of the last 2 years. My lord, I know you will have considered, of course, all of the material in this case, but also in particular the Form RN, so therefore the response by the respondent. And I don't want to short-circuit anything, but I just want to have an understanding of what will assist the court the most in terms of the focus of our submissions. The parties are in agreement so far as the principal ground.
Yes.
But of course it remains always a matter for the Court of Appeal in terms of the safety of the conviction.
Yes.
In light of that.
Well, to clear the decks a little bit, Mr. Pitter, the CCRC, as you say, referred the case to this court. In the usual way, they give reasons for their referral. Your grounds of appeal, in effect, adopt those reasons. You're not seeking to add a completely new point which the CCRC didn't think it appropriate to refer. So we don't need any application for leave. The grounds of appeal go immediately before the court. In very short summary, the principal ground relates to new DNA evidence. Then other grounds relate to proposed fresh evidence about bite marks and proposed fresh evidence about the circumstances in which Mr. Sullivan both made and retracted a number of admissions and confessions in the course of a long series of police interviews. But perhaps we could take each of the 3 points. It's entirely up to you to what extent you wish to develop them. There is, as you say, a lot of common ground between you and the respondent in relation to the DNA position, as it now is, but there's a resistance to your other grounds of appeal.
There is. Well, Lord, if I begin then with the scientific evidence, unless you require me to, I'm not going to summarize in long order the scientific evidence, which, number one, is not in dispute. 2, forensic scientists on both the appellant and also for the respondent have considered the matter carefully and have been able to come to conclusions which are consistent with one another. But what may be of assistance for these purposes, because it is germane to the overall appeal, and in particular in this particular case, relevant also to the consideration of the second and third grounds. And the short summary, if I may deliver it in that way, so far as the scientific evidence is concerned, is this. What was an awful offence and murder in appalling circumstances involved a sexual assault on the deceased, the victim, And as part of that, and I deal with it as part of this point, but it's freestanding in any event. Semen left by the perpetrator has always been said, but the factual reality is, must have been from the perpetrator, left on the deceased's body. Sorry to describe it in that grotesque way, but it was a grotesque offence. At the time that this matter was originally before the court, there was not the scientific capabilities to carry out an analysis of that material. And indeed, over recent times, because this matter has been the subject of subsequent applications to this court, the material was not able to be sufficiently analysed. But what has occurred since 2024, and you have the forensic scientific statements, is that an analysis has been carried out of that material, which has led to the conclusions, and we have set them out. I say this not to ignore the full report, but just because it is easy for you to navigate. Yeah. Our paragraphs 34 of the grounds of appeal.
Thank you.
And in particular, paragraph 34.2. And whilst that is a short summary, it is the summary of significance for your purposes.
Yes.
The DNA profile on the cellular material and the semen samples found on the deceased was not the appellant's, but could be attributed for these purposes to an unknown male.
Yes. And I take that to mean, Mr. Pitter, that if ever the unknown male could be identified, it would be possible to compare his DNA profile with what was recovered all those years ago from Miss Siddall's body.
You have the point. You have the point, my lord. This is not a simple. Well, it just casts doubt on the appellant being the person who is responsible for the semen being present. It in fact positively goes the other way. It is not his, and can be identified to that unknown male.
And there's also no evidence, is there, that more than one person was involved?
My lord, I was going to come to that because it's part of this point, but it's part of a wider point as well, because, in fact, I'll deal with it now. Quite often, when we're considering fresh evidence, of course, the test is the conviction safe, but there is the wider consideration, sometimes deployed, as to the impact on the jury of the fresh evidence. And this is perhaps one of those cases which perhaps starkly illustrates the difference between those two tests, in fact, because the prosecution case is, it was one person. It was one person who carried out a sexual assault on the victim. And the evidence here is, now, that one person was not the defendant. And so then you can see how it would play into both of those tests where there is a difference, but the outcome is the same, in fact. So the impact on the jury would have been massive. Sorry to use it in such bold terms, but that's the reality.
Yeah.
But my lord, yes, to get to the heart of your question, not only was it not just the prosecution case, that there was no evidence to suggest more than one person being involved. And had there been, there is still the absence of the defendant's DNA being present in any event.
I suppose the other side of the coin was, equally, there is no evidence of any innocent explanation for the semen being present either.
Quite, and this is an aspect of the case which was, we understand, considered at the time, but certainly has been considered subsequently, to see if there could be an explanation by and we say this with the utmost of respect, but it's an inevitable part of an investigation like this. Inquiries as to whether or not there was some other person innocently connected with the victim in this case. And that is, those investigations has led to there be no basis for making that assertion. And and if I can deal with it at this point, but you will have seen it already, and hopefully the respondent does not mind me dealing with this narrow aspect, but it is relevant. We can fully understand, and it would have been part of our submission in any event, but we fully understand why. The reality is, with this scientific evidence, if this case was one which was being considered, we don't see how it could have passed a threshold for which a prosecution could take place. That will be explained in, I anticipate, more in clearer detail. I'm being very guarded about how I say that, but I know the respondent will deal with it, but I have to touch on it for these purposes. But placing all of those considerations, not to one side, but just parking them, when one looks at the, as we describe, the horrific circumstances of the murder, it plainly was, a jury would have concluded, one, sexual, and two, whoever was responsible for it was also responsible for depositing semen. That is very, very basic common sense and analysis. And there were features of it. It may well be your lordships deal with it, but the injuries to the deceased plainly point to that. Injuries to her genitalia and to her breasts and to her damage to her clothing. Now, of course, we appreciate the case had many aspects to it. Very simple consideration, or the simple consideration, or simply expressed consideration, is whether or not this evidence, if adduced, would render the conviction unsafe. And in those simple terms, it would. Applying that broader test, might it have had that impact, or an impact on the jury such to render the conviction unsafe? Without question it would, whichever way it's approached.
But the primary role of this court is to decide for itself whether a conviction is unsafe.
It is.
As part of the decision-making process, the court is entitled to reflect on what the likely impact on a jury would have been if particular evidence now available had been available at the time.
Exactly that. Here's my confession. I sometimes find it difficult to separate those two tests in the real world.
Well, you're perhaps not alone in that.
Yes.
Mr. Peter.
But as I say, I appreciate in this case, though, because of the way the case was in fact put to the jury, you can see that there may have been a difference, but it's one which leads to the same conclusion, if that makes sense to you, my lord.
Yes.
So, my lord, in very simple terms, that's not to erode the power of the point. In fact, the power of the point is in its simplicity, in fact. Those are the submissions that we make in respect of the scientific evidence. I deal with it in that shortened form only because I know what the approach of the respondent is to it.
Yes. That's very helpful, thank you.
But I will expand, if you wish me to, on that particular point before I turn to the other two grounds.
Just to flesh it out a tiny bit, one of the problems encountered at the investigation stage, I think, was that I think there had been some rainfall between the murder and the finding of Miss Sindall's body, and so that rather diminished what could be recovered from the body. That which was recovered could be analysed to some extent, but the scientific limitations at the time to which you've referred meant that it simply wasn't possible to make any progress in identifying the source of the semen found in the body.
My Lord, precisely. And we do not make any criticism of the scientific processes or the systems that were deployed at the time. And we recognise that, to highlight your Lordship's point, there was a stage at which, had the analysis taken place earlier than it had, it would have run the risk of destroying the sample altogether.
Yes.
And I highlight that only because we may not have had what we say are the right answers now had that occurred.
Yes.
So we do recognise, Mr. Sullivan recognises, it is the development in science and the passage of time which has significantly assisted his position. We recognise that.
Thank you. Yes, thank you.
Now, my Lord, as I say, if there are other aspects to deal with on that principal point, we will develop them. But subject to that, we would turn to the second and third grounds, which in a sense I can deal with some aspects together, because underlying it we will say that the new scientific evidence inevitably, so powerful is the impact, has an impact on those two grounds. But I'm in your hands, my Lord. It is sometimes easier to analyse these piece by piece, but ultimately we'll be coming back to look at them as they interact with each other.
Yes, well, perhaps the starting point, as you've just said, is that these two grounds relate to particular aspects of the overall case presented by the prosecution. And whatever the merits of the individual grounds, your broad point is that every aspect of the evidence now has to be viewed in the context of the new DNA evidence.
Exactly that, my Lord.
So however strong a particular point may have seemed then, now the court has to consider, well, what reliance can be placed upon that now, given what we know about the DNA analysis?
That's exactly the point. We say that in particular because we recognise there have been previous appeals, previous considerations, but prior to this point. So there may not be the very significant merit in a very careful review in the strict legal sense of each aspect of the decision.
No.
Because you have a unique position coming to this afresh and carrying out a particular test. Yep. And looking at it now. And it would be, in a sense, impossible to look at it in any other way. So the headline point with both of the two aspects, that's the bite mark evidence, to use simple language, and also the admissibility of the evidence, so the confession evidence. It would have been, we say, impossible for any court to consider, in particular, the confession evidence in light of that very important scientific evidence, which of itself underlines the unreliability. And we say it does it to such an extent that this is one of those cases where it's not just because of new evidence, it's the strength of the combined new evidence.
Yes.
Which means you ought to, I was going to say reconsider, that's perhaps an unfair way of considering it, but look at those decisions afresh and make a decision as to whether or not those are valid grounds in the sense of that evidence really would not have been before the court in light of the new scientific evidence. I've expressed that perhaps in a long-winded way, but hopefully your Lordship understands that point. My Lord, there is, for both of those aspects, whether we call it new evidence or developed evidence, the legal effect for both of them is that it is new evidence in the sense of it adds to what has been considered already, but to an extent really does amplify the evidence that was, if not before the original tribunal, before the Court of Appeal on previous occasions, which we would say then places this court in a position where it ought to consider that new evidence. One, to allow its admissibility, because if there were to be a trial now, plainly that is evidence that would be before that tribunal. And also it would have to be considered with the new scientific evidence.
Yeah. Well, I wonder, speaking for myself, Mr. Pitcher, it would help me if you just say a little bit more about what you say these two further statements add to what was considered by this court in 2021.
Of course.
When there was an earlier application for leave to appeal.
Of course, and I will, my Lord, deal with them in that way, if I may. So beginning then with and I'm going to deal with this in as you'll appreciate, there are a number of reports stretching over well over 100 pages. I'm not going to recite all of that for you, my Lord. You'll be pleased to hear. But I am going to give you again the headlines of first of all, the new evidence which goes to the bite mark, first of all.
Yes.
And we take on board the point which understandably exercised the respondent, that perhaps there may have been in one of the reports an overstatement of the significance of this part of the evidence. I'm not engaging in that because we don't need to actually. It's as simple as this. It was part of the prosecution case.
Well, so that those listening understand, one of the awful features of the case is that Miss Sybil's breasts had both been injured, and the prosecution case was that those injuries were caused by biting, by human teeth.
Yes.
And that on the basis of evidence from forensic odontologist, that the particular dentition of Mr. Sullivan could be matched to the marks of injury which were found.
And a feature of it was that the expert evidence was expressed in a particularly high way at the trial.
Yes.
So in the expert's terminology, they were satisfied to the criminal standard as in the expert was. Whether that form of language was appropriate, we have an understanding of how satisfied they were about it.
Yes.
But my Lord, perhaps if for these purposes, rather than taking you to material, as I say, that stretches over several hundred pages, can I just take you to our grounds of appeal which summarise this aspect of the case? And it's the evidence provided by Professor Pretty. And the original report at page 136, considered, of course, on the last occasion. But there is the further report of the 18th of December 2023, page 493. I will, if you permit me, have to deal with a degree of that which has been said previously by him, because it's the foundations of the final conclusions. There is, Professor Pretty's words now, one, no scientific basis for identification and subsequent analysis of human bite marks on skin. And now that the science undermines its use rather than supports it. And that would echo, those familiar with this sort of evidence, echo the practice in court in cases of this nature, that it is not a reliable form of science for the purposes of identification. And again, hopefully not speaking out of turn from my experience, would not be relied on for that purpose in a case of this nature. I'm not saying it can never have relevance, but for that very pure purpose of identification, would not be relied on, we submit. But there is an additional feature, and this is one area where the consideration of the impact on the jury has to be perhaps considered. That, according to Professor Pretty, the evidence in this case is of their word, poorest quality, and in their words, cannot be determined that the injuries were bite marks. Pause there. We recognise that that may not be accepted, but that's not the point in reality. And that's the principal basis upon which it is suggested that the evidence should not have been relied upon. But there is industry standard evidence which is relied upon, which undermines the use of that type of evidence for the purposes of identification. Now, in the spirit, not in the spirit, it's our obligation, in fact. Of course, we are aware, as you are aware, that of course there was some further work carried out in this area by the prosecution, which one shares the view in terms of the overall use of this sort of evidence and the unreliability, but does make that observation that the dentition in this case could be in line with that which was found, but we would say, you'll understand what we mean about this, in a sense, so what from a forensic perspective.
Yes.
It does not have that ability to prove that which would have needed to be proved in a criminal case. In the sense of, no doubt, it could, of course, have covered a vast array of people.
I wonder if you can help me with this, Mr. Pitter, because speaking for myself, I didn't find it entirely clear from Professor Pretty's report. I understand, certainly, his very strong opinion that you can't and shouldn't try to use bite mark evidence as the basis for a positive identification of a particular person. But if what isn't clear to me is whether Professor Pretty would also argue against ever making any use of it whatsoever. And if I can give a hypothetical example far removed from the circumstances of this case, suppose there's been a burglary of a house, and whilst stealing the valuables, the burglar helped himself to an apple and left behind his bite marks in the apple. And I fully understand that Professor Pretty would say that if the only evidence, the only basis for accusing the particular defendant was, well, the bite mark in the apple matches your teeth, Professor Pretty would say that wouldn't be sufficient. But if the evidence was, well, the bite mark in the apple is consistent with it being the defendant, and there was other evidence, an eyewitness who said, I saw a man who looks like the defendant going in, and another witness saying, I saw the defendant, whom I know well, in the pub that night, and he seemed to have come into a lot of money all of a sudden. What isn't clear to me is whether Professor Pretty in that situation would say, well, even so, ignore the apple completely, or could it at least be used as some additional circumstantial evidence? The person identified is someone who at least could have left this bite mark on the apple.
I can't answer that question for Professor Pretty. I'm not going to try. And really the answer perhaps would be this. Much would have to depend, wouldn't it, on the nature of the consistency.
Of course. There may be a big difference between an apple and human skin.
Yes, nature of the consistency and also the nature of the other evidence. But in a case like this where we have, this is why we say there's that interweaving of the points and why this then has to be revisited as a separate point. When you have the scientific evidence, as it is in this case, it perhaps highlights the dangers of it. Hopefully danger isn't too controversial a word. And in particular when it is, as you have identified it, sorry to use technical and scientific terminology, we're talking about a human being at the end of the day, the elasticity of flesh.
Yes.
But as we say, it is that aspect where even if one takes that position of, well, there may be a consistency, as Dr. Kuble has said, with the defendant's bite mark. It's no more than that, but in circumstances where the scientific evidence demonstrates it could not have been him.
Can I put a different scenario to you, though, a variation of the apple one, where, as is sometimes the case, there's a mixed DNA sample, and there's a probability, not a 1 in a billion probability, but a mixed sample, such that a particular defendant can't be excluded.
Yes.
Now, you could have the scenario, there's some DNA evidence, perhaps on the apple, for example, so he couldn't be excluded. You've then got the dental evidence, and then you've got other features.
Yes.
And the nature of a circumstantial case is the whole, not the individual parts. So in that scenario, that could arise as to whether the bite evidence would be admissible as part of that overall circumstantial picture.
I can see circumstance, and it's not dodging the question. It's just, the point is this: I can see circumstances where we can postulate routes to admissibility, and I'm not suggesting in this particular case, because it doesn't arise, there's any sort of ruling which would always exclude this evidence. That's what we're not analysing that. And that's why, in reality, there would have to be that consideration of what the actual other evidence is. And even with the DNA evidence, as you have, my Lord, if I may say, understandably postulated, we have those scenarios where the probability is so loose, so diluted, that even that of itself, because then the population sample becomes too great, has its own flaws. And I suppose then we're coming to this, then it's a question of degree, isn't it?
Thank you very much.
Thank you. But it really does highlight, my Lord, when we start to look at it in that way, it does highlight that very point, in fact, that the new scientific evidence really does bring back into play or into consideration, to be more formal about it, this aspect of the case. Because the Court of Appeal on the previous occasion did not have that what we say, important opportunity to consider this issue in that context of the scientific evidence. My Lord, do you wish me to develop that point any further, or
no, thank you very much. You've been very helpful. Thank you.
To the unreliability of the alleged confession, or what, well, there's no point saying alleged, on the face of it they were confessions and inculpatory statements. The short point is this. My Lord, we framed this, and I should say this, I'll take the hit on this. We've framed this in the grounds under the basis of Section 78 of the Police and Criminal Evidence Act. Perhaps, strictly speaking, that should be Sections 76 and 78. But in reality, in this case, it would make no difference, number one. And number two, in light of where we are now, Section 78 probably fits this scenario better in that it is the overall fairness of the proceedings we're considering. But we're not suggesting anything significantly turns on that in the analysis. Now, my Lord, the point is this, and you have that history, and hopefully you have been provided with the list of areas of concern. I'm not saying it's an agreed document. It's a document prepared on behalf of the appellant, prepared by my junior in the case, of those areas where matters were raised during the course of all of the interviews by the appellant, by Mr. Sullivan, which may have caused some concern. But can I take the headline in this way, our paragraph 44, because it deals with Professor Shepherd's most recent report of last year, 19th of April 2024. For the full bundle, it's page 496. That the confessions of, or the inculpatory statements of the appellant have to be looked at in his inherent long-standing unreliability, and also framed as a vulnerability, which renders the incriminating statements he made inherently unreliable. Now, of course, Professor Shepherd viewed them also, and this is the framing so far as Professor Shepherd is concerned, in the context of breaches of Code C, that a detailed, close analysis of those breaches may not be necessary for today's purposes. Save for this aspect, the significant admissions took place outside of a recorded interview. And therefore not in accordance with the codes of practice. But the point will be made that there was at that time in particular some latitude for those circumstances where an interview could take place outside of the protections afforded by a recorded interview. Now, of course, on behalf of the appellant, we say it should not have occurred. But the real point for you, perhaps, is considering the fairness of this material being before the jury in those circumstances where there were those features, bearing in mind the inherent unreliability. You have the full chronology of the history of the contact, which is quite voluminous, in fact, between the applicant and the police. It's page 626 of the report. But the real point for us here, and this is why we say it's fresh evidence, is that Dr. Shepherd goes significantly beyond Dr. Harry Wood, who may be familiar to some of you, and his report that was originally before the court. It may help for the nature of this hearing if we expand just a little bit. It is important to the applicant, but that's not the reason I do it. It should be important also in the consideration. First of all, we've touched on the long-standing nature of the unreliability. And this is not something that just existed then. It has persisted throughout. And so, therefore, if you needed any reassurance, but it does properly, this is why it is, in a sense, fresh evidence. Inevitably, somebody in the applicant's position has been subject to consideration and engagement with the parole board. And the conclusions there, placing to one side Professor Shepherd, are that in the records there are references to him, as in the appellant giving blatantly wrong answers, inconsistencies, and this may be, to a degree, an explanation for some of what he said at the time, and as being a known fantasist. And him himself, at times having referred to himself as historically being a born liar. Now, of course, as part of the consideration of the original investigation team and the original prosecution, reliance was inevitably placed. I'm not going to make any assessment of the importance of the reliance, just reliance was placed on features of his accounts at the time, which the prosecution say had elements of accuracy and I suppose internal consistency, but also which were also accurate as compared to the circumstances of the offence. Now, what that has to sit to, though, with is the other side of that coin, which is the obvious inconsistencies. Which he delivered when giving his confessing accounts. So therefore making admissions, but inconsistencies both internally with his own accounts, but also inconsistent with aspects of the actual offence itself. And this is an important aspect of the case which we say Professor Shepherd has considered, which had not been done previously, and carried out an analysis of those. It may be suggested some of that is an overreach, but it's a proper analysis of those features. There is also that there is this feature about the appellant, which is his ability to adopt features presented to him as part of his own narrative. And that includes, we would submit, features which were in the public domain. And to summarize then, Professor Shepherd, his words, not mine, the appellant was extremely vulnerable in an interrogative situation, therefore an interview situation, because of his limited intellectual functioning, combined with his problems with self-expression and his disposition to acquiesce, to yield, to be influenced. These are the broad points, manipulated and controlled. And his internal pressure to speak without reflection, and his tendency to engage in make-believe to an extreme extent. Technical term, to fabulize. Page 501 of the overall report. And so we say that those are the aspects which of themselves make the admissions, inculpatory statements, unreliable. And this being fresh evidence of that. We do say, though, and we won't spend too long on this, that those are the features then that have to be considered in terms of the interview process, whether that's viewed in the context of a breach of the codes of conduct, or whether that's just taking a step back, looking at the overall circumstances of the case. But this is one, and we cannot avoid but to consider this in a modern-day context. We're not saying this is the beginning and the end of it, my lord. But one has to consider, and there is sufficient experience of these matters now, I would suggest, in this court to have this sort of analysis. First of all, that consideration that he was not afforded at that time an appropriate adult. Plainly, that would have occurred now, especially in circumstances where, in the material, he was suspected at that time as, this is the terminology used then, mentally handicapped. So not today's terminology. That's the terminology that was used at that time. Secondly, that in the very beginning, and whether it's justified or not doesn't matter really for this point. In those early stages of the interview process, he was denied legal representation. Now, of course, we understand that the reason for that being given at the time was that there was an anxiety whether the solicitor then representing him may, even inadvertently, have disclosed important information into the public domain. It's just in parentheses, or just as an aside, that would have to be a wholly exceptional set of circumstances. We do not envisage that would occur today. But that's an aside, and no more than that, my lord. And the third aspect was that the interview process in those initial stages where the genesis of the admissions occurred were unrecorded. And as we say, that the importance of that is that the first significant admissions. Can I take you to my our paragraph 50, my lord, for these purposes, because it summarizes this position?
Yes, thank you.
The first significant admissions occurred in a single day, really, over the course of 4 interviews. The first was off tape. You'll see the times there, with 2 officers, and then subsequently without legal representation. In 2 interviews, he then, and this highlights the difficulty with this, he then retracted on that same day, before then going into some forms of confession on that day. Now, as we said, that is in the context of there being some internal inconsistencies even with those accounts. and so, my lord, we come to this, even if in isolation you are of the view that didn't amount to fresh evidence. We, of course, say it does in the context of this case, but you will have to, in any event, consider those, and this is the difficulty not difficulty, but this is the unusual features of your consideration. You're considering it at this end of the telescope, but also with the scientific evidence, which we respectfully submit. gives reassurance that not only is this evidence, one, admissible, but it's ought to be admitted as fresh evidence. And we say in isolation, when you consider it, would significantly undermine that evidence, such that the jury either, one, wouldn't now be presented with it, or secondly, if presented, it would be so heavily undermined by that expert evidence in respect of the unreliability of the appellant, and in addition with the scientific evidence, which in essence, can I just be straightforward and plain about it, would leave one with the sense that what he was saying was nonsense, in plain terms.
But may I ask your help on two aspects of this,
Of course.
Mr. Pitter? First of all, many of the points you've been making very helpfully about unreliability, vulnerability, are obvious from reading the interview records.
They are.
They could have been, and indeed were, the subject of evidence and argument at the trial.
Yes.
Let alone in later proceedings. And insofar as you point to the fact that it would all be very different under modern conditions, there hasn't been any material change in that regard since the time of the first appeal in 2021, has there? And then the second aspect I'd be grateful for your help on. A very substantial proportion of Professor Shepherd's report is nothing to do with the psychology of the appellant. It's a critique of the way the police went about their work. And I would just be grateful for your submission as to the basis on which you say any of that is relevant. I don't mean this unkindly, but speaking for myself, parts of the report read far more like a defence closing speech than expert evidence. And on the face of it, you can't call an expert to give a commentary on what the expert thinks of the way the police went about their job. That's the subject matter for submissions by counsel, and it's within the province of the jury.
Can I deal with that second point
please.
first? In these submissions, I'm sticking to the psychology.
Yes. All right. Yes.
And it's the psychology then that we say really underlines, and you'll understand the phrase amps up the points previously made.
Yeah.
Highlighting in no uncertain terms the unreliability. We take the point, of course, there's a lot more, whether it's critique or analysis, than would be before the jury. But that's not what we're interested in. But taking those two aspects, my lord, or taking that aspect, the psychology of it, how do you easily divorce it from the scientific evidence also? So, sorry to remake that point, but we have to, in fact.
No, very valid
because,
point.
Whatever concerns you may have of Professor Shepherd's advocacy skills, at the end of the day, it is underpinned, isn't it, with that scientific evidence, as in the psychology is underpinned with the scientific evidence.
Thank you.
So those are the submissions we would make in perhaps briefer form, because we know you have them in writing and in full. But taking then a step back, one, of course, you as perhaps you always would do, would consider each point individually, but they have to be considered collectively as well for these purposes. Of course, the bold point is the fresh DNA, scientific evidence. But in the end, your single consideration is the safety of this conviction, which inevitably involves the interaction of all three grounds. And so therefore, in the circumstances, and we accept there may actually have to be some nuance so far as grounds 2 and 3. We have steered away from a very close analysis of decision-making processes previously in different circumstances. It's what's right today. And what is right today when one takes a step back, applying whether it's legal standards, human standards, it doesn't really make a difference in this case. It's the safety of this conviction, which we say in light of those matters is rendered unsafe. I don't know whether there are other areas which your lordships would like me to expand.
No, thank you very much indeed, Mr. Pitter. That's all been extremely helpful. Yes, Mr. Atkinson.
Please, my Lord. In assessing now, in 2025, the safety of this appellant's conviction in 1987, it is right to note that there is a proper distinction to be drawn between what is a truly new ground of appeal, namely that relating to DNA evidence that has not previously been put before any court because it could not have been, and grounds that were advanced on behalf of this appellant in 2021 relating to the reliability of admissions in interview and the reliability of the ontological evidence that were considered by this court in 2021 when leave to appeal was refused. In 2021, this court concluded that the new evidence as to the reliability of bite mark evidence did not undermine the safety of this appellant's conviction, where the case against him was a multifaceted one that did not depend either solely or mainly on that evidence. And secondly, that in relation to his admissions in interview, consideration had been given at his trial and subsequently to the reliability of him and of his admissions, and that the learned judge at trial had been entitled to rule them admissible on the material at that time. And insofar as those two grounds are concerned, grounds 2 and 3, the respondent now submits that this court can and should reject those grounds for the same reasons that this court did reject them in 2021, that the conclusions reached then were proper, and that the fresh evidence now provided since then does not alter that position. And I'll return to that with my Lord's leave a little later. But so far as the new ground is concerned, the respondent agrees that the DNA evidence now provided to this court is capable of satisfying the test for the admission of fresh evidence under Section 23 of the Criminal Appeal Act of 1968. We recognise that it is for the court to determine the effect that that has on the safety of this appellant's conviction. But we do not oppose the admission of the evidence from both Karen Alexander, instructed by the CCRC, and Dan Beaumont, instructed by the respondent. And we do not seek to argue that this fresh DNA evidence does not undermine the safety of this appellant's conviction. My Lords, the test that this court will apply is very helpfully set out from paragraph 75 of the decision of this court in Campbell, which is a case that I know the court is very well familiar with. I cannot and do not seek to improve on that analysis. But, My Lords, if my Lords will forgive me, it does seem to the respondent important that the factual background and how we have come to be where we now are is properly understood. We are conscious it is understood by the court, but it is important that it is understood by all those present in court. And so I hope my Lords will forgive me if I briefly set out some of that background before turning to the grounds.
Yes. You can assume that in our judgment we will to some extent be outlining
Absolutely.
Events and the course of various proceedings.
Thank you very much, Paul. And so, as my Lords know, in August of 1986, Diane Sindall left her work at the Wellington Hotel to travel home at about 1:45 Her van broke down. Her body was not found until 12:30 on the afternoon of the 2nd of August in an alleyway off Borough Road in Birkenhead. As was made clear at this appellant's trial, she had been subjected to an attack that was not only violent but also sexual. Traces of semen were swabbed from her upper abdomen, but they had been diluted by rainwater and were not susceptible to scientific analysis. And it is important to stress that it is not that that evidence was missed, it was that it could not be done. And indeed, when this case was first considered by the CCRC in 2008, that remained the position. Ms. Sindall had suffered extensive and serious injuries, including a fractured skull and underlying brain hemorrhage. Her breasts appeared to have been bitten, and it was a combination of factors that identified this as a sexual assault as well as a violent one. Some of her clothing and possessions were missing, but were recovered some 2 weeks later, partially burnt at a location called Bidston Hill.
But just pausing there, if I've correctly understood one detail, the jewellery which she was wearing remained on the body.
Yes.
So nobody had stolen
Yes.
her valuables.
And so that, if anything, supported the contention that this was a sexual rather than any other kind of motivated attack. In terms of the evidence that emerged from the police investigation that identified this appellant as a suspect, first, he had been seen by a number of witnesses on the evening in question at a public house some 10 minutes walk from the scene of Ms. Sindall's assault. And he had left that location at a time which would have allowed him to have reached the scene of that assault by the time it took place. Second, in relation to the evidence disposed of on Bidston Hill, 2 witnesses identified him, at least by description, as having been at that location. Third, at the time of the investigation, there was also material provided to the police by the appellant's partner that was implicating of him. That was no longer available by the time of his trial, but did feature at the time of the investigation. Fourth, there was evidence from a neighbour that the appellant had borrowed a crowbar from them shortly before the date of the murder and had returned it afterwards. And the crowbar was confirmed as a possible candidate for the causing, in particular, of the fractured skull and injuries of that nature. Fifth, there was a degree of fibre evidence. It was of limited value, but it did identify that brown fibres that were found at the scene could have originated from a garment that was also linked to fibres found at the appellant's address. And so there was that limited further fibre evidence. It was noted, sixthly, that Mr. Sullivan had left the area and gone to London between the murder and his identification as a suspect. And so, before one approaches the grounds now, it is right to note that there was at the outset a cogent circumstantial case against this appellant, excluding those matters that are now the subject of the appeal and leaving, of course, to one side the DNA evidence that has now emerged, which was not available at the time of his trial. In terms of his interviews, it is right to note that access to a legal representative was delayed to him, but it is also right to note that that was on a considered basis and through an application of Annex B to Code C, to the Codes of Practice under the Police and Criminal Evidence Act, by a superintendent whose reasons were recorded and are also recorded in the superintendent's report, which the respondent made available during the course of these appeal proceedings. A concern that early access to a solicitor would allow material that was particularly sensitive in relation to the nature and circumstances of this killing to get into the public domain at a time when that could undermine the investigation and put at risk the recovery of evidence. And that was a reasoned decision in accordance with the code. It is right to note that the appellant did not have an appropriate adult in his interviews. Contrary to the assessment of Professor Shefford, that was not an obvious requirement at the time in relation to what was quite a new provision of the Police and Criminal Evidence Act at the time, nor was it a matter that the solicitor, when they were present during the interviews, sought to address. During the course of the initial interviews, the appellant gave a number of contradictory accounts as to where he had been at the time of the murder and on the evening of the murder, giving different accounts, for example, as to whether he had been with his girlfriend, with a friend, or elsewhere, and also giving contradictory accounts as to whether or not he had gone to Bidston Hill, where he had, of course, been seen. Ultimately, he did then go on, first in an interview that could not be recorded, and then in an interview that was, to make admissions in relation to the murder of Diane Sindall. He did go on later to retract those, but it is of note that once he had been afforded access to a solicitor, he both then further made the confession and then retracted again. And so in that respect, the presence or absence of the solicitor does not appear to have made a difference to a pattern of confession and retraction over the course of the interviews. It was relied on as part of the case against him that there were aspects of what he said in his admissions that touched on matters that were not matters of public knowledge at the time. For example, some details as to Miss Sandell's clothing, that her body had been dragged and the like. There were contradictions also, but as my Lord has already rightly observed, all of that was obvious from a proper reading of the appellant's interviews, that it did not require a psychologist to decipher. It was clear on their face. And that was, of course, material that was considered by the learned trial judge, the then Recorder of Liverpool, when an application was made to exclude the interviews. It is also right to note that whilst he was on remand, Mr. Sullivan repeated his confession to a fellow prisoner. That was, again, material available at the time of his prosecution, as was the fact that whilst going through the interview process, he was permitted to speak to his mother and recorded as saying that he could not bring himself to admit to his mother what he had done. In terms of the ontological or bite mark evidence, which is easier to pronounce, that featured, it is right to note that by the time of trial, it was given in emphatic terms, and it is perhaps the emphatic terms of that bite mark evidence that are the matter of concern, rather than its existence as evidence at all. Dr. MacDonald gave evidence that he was left in no doubt at all that the marks on Diane Sindall's breast had been caused by the teeth of Peter Sullivan. And Dr. Scott gave evidence that although he initially believed it was unlikely that Mr. Sullivan was responsible, he changed his mind and now agreed with Dr. MacDonald. And it is also important to stress, we submit, that at the time of the trial, expert evidence of that kind from two respected experts was regarded as being expert evidence in its proper sense and support for the prosecution case. But it was never the sole or decisive evidence against this appellant, as this court observed in 2021. Finally, so far as the background is concerned, it is right to note that at his trial, this appellant did give evidence in his own behalf. He said, having come up with a number of different explanations over time, that at the time of the events in question, he'd been at a public house playing darts, had left with a woman and her mother, that they had travelled to buy fish and chips, and he had then walked home via another fish and chip shop. He said that he had not been to Bidston Hill, he had not got his neighbour's crowbar, that in relation to his previous accounts about his movements, that his mind had been mixed up and he told different accounts because he couldn't remember what he had been doing, and that his confession that had not been recorded had been the result, he said, of verbal abuse and assault by the interviewing officers. He said he could not remember having made admissions to another prisoner on remand. So, my lords, against that background and the conclusions reached by this court on the previous occasion, may I then turn to the grounds of appeal themselves? And firstly, to ground one, the DNA evidence. As I've already touched on, my lords, the evidence now advanced as fresh evidence from Karen Alexander that has been reviewed and is now supplemented by that of Dan Beaumont, instructed by the respondent, could not have been available at this appellant's trial, and indeed could not have been available even in 2008 when the CCRC were first invited to consider his case. But what it does now address is the semen that had been found at the time on Miss Sindall's abdomen and elsewhere on her body. And it is important, in fairness to the appellant, to recognise that the prosecution had always put its case that that semen was there because her assailant had ejaculated on it. That was how that evidence was addressed at that time. But the new DNA evidence does identify that the profile obtained from the swabs taken from those samples has been given the identity unknown male 1, that it is 1 billion times more likely that the profile originated from unknown male 1 than someone else, and that it did not match this appellant. It is also right to note, because of the thorough work that has been done, that it also did not match the DNA of Miss Sindall's partner or of the scientist who took the samples in the first place. That is a exercise of analysis that has been checked, as I've indicated, by Dan Beaumont, who agrees with those conclusions, and we, for the respondent, submit that this court, therefore, is entitled to take that evidence as entirely reliable and, in those respects, meeting the test in section 23.
May I just interrupt you for,
Yes,
for one moment, Mr. Atkinson, just in case there's any misunderstanding or doubt on the part of others listening to this case. When you talk about the DNA profile of unknown male 1, that, as I understand it, is the profile recovered by analysis of the samples
Yes.
in this case.
Yes.
So no one should think there's a database somewhere with an existing profile on it.
No.
This is one of the samples enabled the scientists to produce a profile, which, as I suggested to Mr. Pitter, could now be compared with someone should unknown male 1 ever be identified to the police. Thank you very much. I just wanted to clarify that, lest anyone was puzzled by the reference to the profile. And perhaps also, whilst I'm interrupting you, if I can carry on doing so for a moment, we ought perhaps just to make clear again for the assistance of the public that one of the important features here is not just that it's analysis of a DNA sample, but it's the DNA from the semen.
Yes.
So we haven't got the semen in one place and then some DNA in another location on the body. It's the DNA extracted from the recovered semen.
Yes. And Lord, that is why the new DNA evidence is so potentially important, though of course it's for the laws to consider, because, as I indicated, the Crown's case is that this was the semen of the assailant, and the DNA from the semen is of unknown male 1. It is not the DNA of this appellant.
Yes.
I've already indicated it was also not that of Miss Sindall's partner, and it is important to make clear, touching on a point that Justice Bryan has already made, that there is absolutely no basis to suggest that the DNA could have come to be there, the semen could have come to be there through any consensual activity between Ms. Sindall and anyone else. The police were, and the Crown are, satisfied there is absolutely no basis for any such suggestion. This is DNA resulting from the assault that was upon her and from nothing else. It's also important to observe that had this evidence been available at the time, it would not necessarily have meant that the police investigation would have stopped. Clearly there would have been efforts to identify unknown male 1. Consideration could also, back then, have been given to consideration as to whether the offence involved unknown male 1 and the appellant. But that would have to have been something considered back at the time of the police investigation. It is certainly not something that could even conceivably be investigated now. Any such investigative opportunities have been lost. And there is, therefore, on the material available to this court, no other hypothetical route to addressing this DNA evidence other than that it is DNA from Miss Sindall's assailant, and that assailant was someone other than this appellant. And so applying the alternative test set out in Pendleton and quoted by my Lord, paragraph 81 in Campbell, the respondent here does not suggest that a jury possessed of this evidence could not have adopted a very different approach to the circumstantial case against Mr. Sullivan than it did. Because as with any circumstantial case, it is the combination of the different facets of that case that together are demonstrable of guilt. But where an unassailable evidential component points in diametrically the opposite direction, the respondent recognises it cannot be suggested that does not undermine the prosecution's case in such a way as to render the safety of such a conclusion as it would otherwise have been. And, Lord, we observe in the context of the question of resultant orders were this court to quash this appellant's conviction, that it seems to us that had this DNA evidence been available at the time the decision was made to prosecute, it is difficult to see how a decision could have been made to prosecute in the face of this DNA evidence.
Well, can you actually conceive of any basis?
I'm so sorry.
Can you actually conceive of any basis upon which it could have?
No.
Exactly.
And will we submit that that conclusion, which must be the case on that evidence, will inform this court both as to its conclusion as to whether this conviction can be described as safe and what would follow if it were to conclude that it were not. Lords, we submit that the same does not apply to the other two grounds of appeal. And turning, if I may, then to ground 2 and the confession evidence. I've touched already on the fact that the criticisms made, particularly by Professor Shepherd in his report in relation to the application of the Police and Criminal Evidence Act, we submit do not now represent anything like fresh evidence that would undermine the approach that this court adopted in 2021. The decision to commence the intervening process without a solicitor present was taken through a proper application of Annex B to Code C. There was a proper basis for it not to be identified that an appropriate adult was needed at that time, nor did the solicitor, when they joined, suggest that there was. But in assessing whether there is new evidence in relation to the interviews, we submit that focusing on that which is psychology from Professor Shepherd, he is not actually saying anything new, with the greatest of respect, about either Mr. Sullivan or his vulnerability or his low intellectual functioning. All of those were appreciated, certainly by the time that this court considered the matter in 2021, and were recognised to a very significant extent at the time of this appellant's trial. The elements of the interviews highlighted by my learned friends in their schedule of concern, again, were all matters that were obvious at the time, and at the time the matter was considered by the trial judge and again by this court. And we submit that on a proper analysis of the interviews, it cannot be said that the questioning of Mr. Sullivan was oppressive, was leading, it was robust, but not more than that. His admissions were unprovoked, and he was able, even under robust questioning, to maintain a position when he chose to do so. And so, although my learned friends now rely on Section 76 of the Police and Criminal Evidence Act, we submit there is no evidence of oppression or anything said or done to render that which was said unreliable, and certainly nothing new in what's provided by Professor Shepherd in that regard. Equally, the contradictions or inconsistencies in the appellant's account were again matters that were obvious on the face of that account, obvious through a comparison of that account to the other evidence, and were identified and identifiable at the time of his trial. My Lords, we recognise that the case of Campbell was drawn to our attention by the court. It is a case that itself considered new evidence in relation to interviews. We submit that there are a number of differences between that case and this. In the present case, there has been a very recent appeal in 2021 that reviewed fresh psychological evidence that had become available. That was not the case in Campbell. In Campbell, they rejected criticisms of this court's earlier decision in that case to dismiss the earlier appeal, where they concluded that the confession evidence was not the substantive basis for the case against the appellant. But thirdly, the reasons that this court allowed for the appeal were based on the updated psychological evidence, which did inform a different and better understanding of relevant factors that was not available earlier. that was not the case in this appellant's case, because such evidence was, for example, available by the time this court considered the matter in 2021. Moreover, in this case, the jury in Mr. Sullivan's case had a mixture of evidence, including but not limited to his admissions, against which to consider the accuracy of his confession. That was, on our reading of it, not the case with Mr. Campbell, who had been diagnosed with a learning disability, whereas this appellant had not. And so we submit that the case of Campbell is not so akin to the present case as to warrant the same approach being adopted here as was done there. We do, however, in passing, submit that the observations that this court made at paragraph 128 of Campbell about the report from Professor Johnson in that case perhaps do have some resonance with that of Professor Shepherd here. The court observed that the expert in that case was engaging in advocacy rather than focusing on objective assessment and dispassionate opinion. We respectfully submit that in a great part of his report, the same could be said of Professor Shepherd. And we respectfully submit that his evidence is not new, fresh evidence so as to meet the test in section 23, nor does it undermine the safety looked at on its own of this appellant's conviction. We submit the same can be said in relation to ground 3 and the bite mark evidence. This court observed in 2021 that the bite mark evidence was a part of the case, but not the significant part of that case. We submit that is a proper analysis. We submit that is a better analysis than that of Professor Pretty, who now contends that it was the central evidence in the case against this appellant. It was not. Submit also, well, going back to the example of the apple that my Lord raised, that the evidence from Professor Pretty makes clear that there is now recognised to be no scientific basis for identification from bite marks in the way that, regrettably, the experts at the time of this appellant's trial did. Certainly not for them to advance identification evidence in the emphatic terms that they did. But my Lords will have noted the reference in the CCRC's report, from my Lord's notice at page 25 of the CCRC report, to the evidence obtained from Roland Kubel, Dr. Roland Kubel, at the time that the CCRC was considering the matter before it was last put before this court. And what emerges from a combination of Dr. Pretty and Dr. Kubel, we submit, is that there were features of consistency between the marks identified to Miss Sindall's breast and bite marks from a human, firstly, and secondly, consistency with features of the dentition of this appellant. We respectfully submit that evidence of that sort, with those limitations, is properly admissible evidence. And so to take my Lord's collective examples in relation to the apple, it would be perfectly proper, we submit, for expert evidence to inform a jury that the bite to the apple had been made by a human, that it was consistent with identified features of the dentition of this person, but that would not be sufficient in and of itself to allow the jury to be sure of his involvement in the offence. It would, we submit, be capable of supporting DNA evidence of the kind that my Lord Mr. Justice Bryan alluded to. The issue we submit, however, here for this court is to consider whether that overstatement of that evidence at the time of this appellant's trial renders his conviction unsafe. And we submit that for the same reasons this court concluded in 2021, it does not. It was a part of the evidential picture that even if that were put to one side, the jury would have nevertheless had the remainder of the, at that time, cogent circumstantial case to consider. And so, my lords, in conclusion, we recognise that it is ground one that has made the difference between where this court was in 2021 and now. That those grounds that were previously considered and rejected were rightly rejected and should be rejected by this court, but that the DNA evidence now available does make a significant difference and would entitle this court to conclude that this appellant's conviction is unsafe.
Thank you very much indeed, Mr. Atkinson. Mr. Pitter, can you reply?
Just very, very briefly on, I think it's 4 points. Firstly, as far as Campbell is concerned, we had some apprehension going into any detail with your lordships about Campbell, perhaps for obvious reasons. But the observation we do make in respect of Campbell is this, that what is echoed by your lordships, and we have in mind those observations at paragraph 133. We say this more for the record than anything else. And we see some of the important similarities with this case in a broad sense, because in Campbell there is that recognition of important developments in the law, and we would say in the evidence, also in matters of practice and procedure relevant to a fair trial. So therefore your lordships adopting what in reality we are concerned with, which is the fairness and safety of convictions. But at paragraph 133, your lordships observe this: as a result of the fresh expert evidence, this is the point, and this is perhaps germane to consideration of the impact of the DNA evidence, in fact. As a result of the fresh expert evidence, the whole approach to the case would now be informed by a different and better understanding of relevant factors. Now, we appreciate in that case there was a sharper focus on, in that case, the psychological evidence. But in fact, in essence, we would submit that that is the approach to take, looking at the whole approach to the case in a sense. And as your lordship went on, it follows that the conduct of the trial would have been materially different if the information had been known at the time. Recognizing, of course, that in doing so, in that case, your lordship specifically were not criticizing the management of the trial and the trial process in the previous hearings. So that is so far as Campbell is concerned. Proper point raised in respect of then Dr. now Professor Gudjonsson. But what your lordships were able to do was delineate the analysis from the expert evidence. And we appreciate that is the appropriate way to do it in this case. Ultimately then, being able to rely on the expert evidence. Can we just, in light of what has been submitted, to just make sure one or two matters are entirely plain? It isn't just that the prosecution have missed any opportunity to explore whether or not there may have been more than one person involved. I don't think that's what was intended to be suggested, but just in case anybody thinks it, there just is no evidence in any event that there was more than one person involved in this. Also, so far as the scientific evidence is concerned, to reinforce the point, the new evidence would not in reality be just that evidence relied upon by the defence, but also Dr. Beaumont as well, two of them together. And it is...
I missed that. Did you say Dr. Beaumont?
Sorry, Mr. Beaumont.
Mr. Beaumont, yes. Just on that, it's a tiny detail, but I think the CCRC obtained reports from, I think, Miss Atkinson and Mr. MacDonald.
Yes.
And really one has to read both of them together because they're
yes.
different aspects of the analysis.
They are.
Then the respondent asked Mr. Beaumont to review their findings, and he essentially agreed in all material respects.
So in reality, the fresh evidence is the three of them in conjunction.
Yes.
And also this final bit of detail, this is the analysis of DNA in Ms. Sindall's body from multiple sites.
Yeah.
And then two very brief points then on first the psychological evidence. The observation has been made in terms of how he was able to behave, and that there are no specific events that are pointed to. But in reality, with this sort of material, and this is why the observations in Campbell are important, it's the overall impact on him and the reliability of his evidence. I perhaps didn't take on your Lordship's invitation with the thrust I should have in terms of, well, these matters were before the jury, just to make that point plain. The importance of the psychological evidence is that it helps the jury to make sense of those points. It contextualizes those very inconsistencies to help the jury understand and assess either the differences in account or his actual evidence. And then finally, the bite mark, as we touched upon, and hopefully that point was made plain, but did arise in response, understandably, from my learned friend. It's, of course, that quite extreme, and we say inappropriate phrase of "in no doubt," expressed by the expert. That is in part the concern, because there was no scientific basis even to say that on his analysis we would submit. In a sense, that's part of the danger of that, where an expert, then we had two experts at the time, expressing themselves in that way to a jury. But as we say, when one then takes Campbell and looks at it in the proper context, it impacts on that type of evidence. So, my Lord, I promised I'd be brief in response. Those are the submissions in response, unless there are matters I can assist you with.
No, thank you very much. We're very grateful to all counsel for those extremely helpful submissions. We're going to rise to consider them, and it will inevitably take us a little while. But I'm conscious there are a lot of people in the courtroom who've been listening very intently. So to assist everyone to know where they stand, we certainly won't come back in before 20 past on the court clock. It may well be later than that, but for at least that period, everyone can regard themselves as safe to go and stretch their legs.
Thank you very much.
I do emphasise by that clock, because not all clocks in this building show the same time as one another. Thank you.
Court rise if able.
Just pull that out. Yes, do sit down, please, Mr. Sullivan. Thank you. Diane Sindall, aged just 21, was attacked and killed as she was making her way home from work on the night of the 2nd August 1986. On 4th November 1987, after a trial in the Crown Court at Liverpool, before the Honorary Recorder of that city, His Honour Judge Temple, Queen's Counsel and a jury, this appellant, Peter Sullivan, was convicted of her murder. He was sentenced to life imprisonment and a minimum term of 16 years was specified. He has remained in custody ever since. Further evidence has now been obtained by the Criminal Cases Review Commission, CCRC. In particular, advances in the methods of DNA analysis have enabled forensic scientists to provide important information about the source of DNA recovered from Miss Sindall's body. The CCRC have referred the case to this court. The reference by the CCRC takes effect as an appeal against conviction. At the heart of the appeal is an application by the appellant to adduce fresh evidence relating to DNA analysis, to bite marks, and to the reliability of confessions made by the appellant to the police. This court must consider whether to exercise its power under Section 23 of the Criminal Appeal Act 1968 to admit some or all of that evidence. The court must then decide whether the conviction of the appellant remains safe. Summary of the facts. Miss Sindall lived in Birkenhead with her fiancé. On the night of her murder, she ran out of fuel whilst driving home from her part-time job as a barmaid. She left her vehicle and began to walk along a main road. She was seen by witnesses around midnight. At about 2:30 a.m. the following morning, her car keys were found on the pavement not far from an alleyway. Around lunchtime that day, a woman who was walking her dog found Miss Sindall's body concealed by vegetation at the end of the alleyway. Later investigation showed that Miss Sindall had been dragged along the alleyway to that location. Miss Sindall's body was clothed only in her t-shirt and bra, both of which were hanging loosely around her neck. Her other clothing, her shoes and her bag were missing, but her jewellery had been left untouched. The medical cause of Miss Sindall's death was cerebral hemorrhage and fracture of the skull caused by multiple blows to her head. Her injuries included fractures of the jaws, fracture of the thyroid cartilage, and facial lacerations and bruising. The nipple of her left breast had been bitten off, and the right nipple had been mutilated by biting. There was a jagged laceration of her external genitalia. The brutal attack, which ended Miss Sindall's young life, also blighted the lives of her fiancé, her family, and all those who knew and loved her. We offer our condolences to the bereaved. The police investigation and arrest of the appellant. Traces of semen were recovered from the abdomen of Miss Sindall's body. The sample had been diluted by rain which had fallen. The scientific techniques available at the time were not sufficient to enable any identification of the man who was the source of the semen. Fibres, which could have originated from brown polyester trousers, were recovered from Miss Sindall's body and clothing. On 2nd August 1986, smoke was seen from a fire at Bidston Hill, about 2 miles from the scene of the murder. On the afternoon of 3rd August 1986, a Mr. Griffiths, who knew the appellant, saw him emerging from bushes on Bidston Hill and running. However, neither Mr. Griffiths nor his girlfriend, who was with him, picked out the appellant at a later identification procedure. On either the 2nd or the 3rd August 1986, walkers on Bidston Hill passed the site of a fire and saw a handbag, the back pocket from a pair of jeans, and a bank paying-in slip in the name of Miss Sindall. On 17th August 1986, police officers found evidence of 2 fires at Bidston Hill. They recovered items belonging to Miss Sindall. The prosecution case at trial was that the appellant had set a fire on 2nd August using an accelerant in order to burn Miss Sindall's clothing, had returned the following day to check, and had then set a second fire. On 18th August 1986, the appellant was seen by police officers. He was carrying a suitcase and said he was going to London in search of work. He gave a witness statement describing his movements on the day of the murder. In September 1986, witnesses provided information which caused the police to speak again to the appellant. The appellant's home was searched. Fibres were recovered which matched those recovered from Miss Sindall's body, though the expert evidence indicated that only limited significance could be attached to that finding. A crowbar was also found, which the appellant admitted had been in his possession around the time of the murder. In the opinion of the pathologist who had conducted the post-mortem examination, Miss Sindall's injuries could have been caused by that crowbar. The appellant gave a voluntary interview to the police, initially not under caution, giving an account of his movements which was very different from his earlier witness statement. He denied ever having been to Bidston Hill and said that at the time of the murder he had been at home with his partner. She, however, later told the police otherwise and made statements, some of which were incriminating of the appellant. When told of this, the appellant put forward another different account of his movements. Without naming Mr. Griffiths, the interviewing officers read out part of Mr. Griffiths' witness statement. The appellant said that he knew who it was who had seen him, stating that it was Mr. Griffiths. He accepted that he had been on Bidston Hill on 3rd August 1986, but said he had gone into the bushes to urinate. The appellant was then cautioned. He became distressed and denied having killed Miss Sindall. He was arrested. He asked for a solicitor, but access to legal advice was for a time refused. There followed a number of interviews in which the appellant repeatedly changed his account. At different times he made admissions which included that he had hit Miss Sindall with a brick, that he had hidden her clothing on Bidston Hill, that he had burned her clothing, and that he had thrown away a pair of brown trousers. At other times he retracted those admissions. The appellant was later permitted legal representation. In further interviews with his solicitor present, the appellant again made and then withdrew admissions. 10 of the appellant's teeth were missing. Dental impressions were taken of his remaining teeth and compared with the marks on Miss Sindall's breasts. An oral pathologist, Dr. Scott, provided a report in which he provisionally concluded that the injuries to the right breast did not appear to be bite marks, whilst the injuries to the left breast were consistent with being bite marks, but it was unlikely that they had been made by the appellant. Dr. Scott recommended that the police obtain a further opinion from Dr. MacDonald, a forensic odontologist. Dr. MacDonald provided a report in which he concluded that the injuries to the left breast were human bite marks made by the appellant, and that the injuries to the right breast could also be human bite marks made by the appellant. Having considered that report, Dr. Scott agreed with Dr. MacDonald's opinion. After that expert evidence had been obtained, the appellant was further interviewed in October 1986. He denied having killed Miss Sindall, but admitted that he had taken the crowbar out with him on 2 nights, that he had been drinking on the night of the murder, and that he sometimes had blackouts when angry. The appellant was charged with the murder and was remanded in custody. In November, it was alleged that he had made admissions to a fellow prisoner to the effect that he had enjoyed the murder and had ejaculated. The appellant and his partner married before the trial. She was therefore not called as a prosecution witness. The trial. At the start of the trial, defence counsel made 2 applications which were refused by the judge. First, that Mr. Griffiths should be called to give evidence, or that any admissions consequent upon the appellant having been told what Mr. Griffiths had said should be excluded. And secondly, that the appellant's admissions in interview were inadmissible because of police misconduct. The prosecution contended that there was a sexual aspect to the killing. They presented a circumstantial case against the appellant, which included the following features. A. The appellant had been in a public house about 10 minutes' walk from the scene of the murder on the night of the killing. He had left at about 11:30 p.m. B. The appellant had borrowed a crowbar from a neighbour shortly before the date of the killing. That crowbar could have been used to inflict the injuries suffered by Miss Sindall. C. Fibres recovered from the appellant's home could have come from the same garment as the fibres found on Miss Sindall's body and clothing. D. Mr. Griffiths was not called to give evidence, but the appellant's shifting accounts in interview included an admission that Mr. Griffiths had seen him on Bidston Hill on 3rd August 1986. E. The fact that some of Miss Sindall's property had been found on Bidston Hill was publicised. It was soon after that that the appellant left for London. F. Doctors MacDonald and Scott gave evidence in forceful terms in Dr. MacDonald's case that the appellant had caused the bite marks to Miss Sindall's breasts. G. The appellant had made admissions in interview, including details which the prosecution said could only have been known to the killer. The appellant gave evidence in his own defence. He put forward an alibi for the time of the killing. He denied having had the neighbour's crowbar in his possession on the night of the 1st, 2nd August. He denied going to Bidston Hill that weekend, and he said that he had given different accounts to the police because he could not remember his movements. He said he had named Mr. Griffiths because he had seen the name on the witness statement which was read to him at interview. He said he had made confessions which were not tape recorded because he had been assaulted and abused by police officers. He denied having spoken to the prisoner who had alleged that the appellant had confessed to him. At a very late stage of the trial, proceedings were adjourned to enable counsel to consider a disclosure by the prosecution of the fact that an unnamed man had told the police that he had found Miss Sindall's body at 6 a.m. on the 2nd August 1986, had stolen her clothes and belongings, and had taken them to Bidston Hill to burn them. The man concerned had then retracted that admission, and the police had eliminated him from their investigation on the basis of the bite mark evidence. This development in the case was ultimately dealt with before the jury by the reading of certain agreed facts. The appellant was convicted and sentenced as we have indicated. Leading counsel who had represented the appellant at trial advised that there were no arguable grounds of appeal against conviction. The first application to the CCRC. In 2008, an application was made to the CCRC. The CCRC agreed exceptionally to review the case even though there had been no appeal against conviction. They consulted forensic scientists whose opinion was that there was no real prospect that further testing of the material recovered during the investigation would produce a DNA profile. The CCRC therefore decided not to refer the case to this court. That decision is not challenged on behalf of the appellant today. We observe that on the basis of the scientific techniques available at the time and the expert opinions obtained by the CCRC, their decision was plainly correct. The first appeal to this court. In 2019, the appellant applied for an extremely long extension of time, some 32 years, to apply for leave to appeal against his conviction. His grounds, in summary, were that fresh evidence was available which showed the bite mark evidence, as we shall refer to it for shorthand convenience, and the confessions made to the police to be unreliable. Professor Ian Pretty had provided a report saying that there is no scientific basis for the identification and analysis of human bite marks on skin, and that the injuries to Miss Sindall could not be identified as human bite marks. Dr. Harry Wood, a forensic psychologist, provided a report in which he assessed the appellant as being of low intelligence, highly suggestible, and highly compliant. For those reasons, he opined the admissions which the appellant had made in interview may need to be treated with caution. It was submitted on behalf of the appellant that if he were being interviewed in 2021, the process would be very different. The interviews would be recorded, and the appellant would have the assistance of a solicitor and probably also of an appropriate adult throughout. The applications were refused by the single judge and, when renewed, refused by the full court. The court found that nothing approaching an adequate explanation had been given for the very long delay in bringing an appeal. Both the single judge and the full court nonetheless went on to consider the merits of the grounds of appeal, in a case in which the bite mark evidence was only one facet of the circumstantial case. The court held that the bite mark evidence had been challenged by the defence at trial, that the jury were aware of Dr. Scott's change of view, and that Professor Pretty's evidence, even if it qualified as fresh evidence, could not render the conviction unsafe. As to the reliability of the confessions, the court held that the judge had ruled on the issue of admissibility, and the defence were able to, and did, deal with all other relevant aspects of the evidence. The appellant subsequently made a second application to the CCRC. It was that which resulted in the referring of the case to this court. The grounds of appeal. The CCRC's 3 reasons for referral have been adopted as the grounds of appeal. They relate to new DNA evidence, a further report from Professor Pretty in relation to the bite mark evidence, and a report from a forensic psychologist, Dr. Shepherd, said to cast doubt on the reliability of the confessions made by the appellant to the police. In relation to the first ground, the CCRC obtained expert evidence from 2 forensic scientists, Miss Alexander and Mr. MacDonald. They indicated that as a result of recent advances in the techniques of analysing DNA, it is now possible to establish that the semen recovered from Miss Sindall's body contained the DNA of an unknown man who was neither the appellant nor Miss Sindall's fiancé. As to the second ground, Professor Pretty repeats his earlier views and now adds that the British Association of Forensic Odontology no longer endorses the positive identification of suspects by reference to bite marks, nor does the equivalent body in the United States. As to the third ground, Professor Shepherd refers to evidence pointing to inherent unreliability of the accounts given by the appellant, to the appellant's low IQ, and to his high level of suggestibility. Professor Shepherd concludes that the appellant was extremely vulnerable in an interview and that the difficulties which he faced were compounded by breaches of the code of conduct which then governed police questioning of suspects. The submissions to this court. We have been greatly assisted by the excellent written and oral submissions of counsel on both sides, to all of whom we are grateful. For the appellant, Mr. Peter King's counsel and Mr. Little Hales submit that all of the proposed fresh evidence should be admitted by the court should be received by the court under Section 23 of the 1986 Act. They rely on the 3 pieces of evidence which we have summarised, both individually and cumulatively. Mr. Pitter very properly recognises that it is the passage of time and the advances in scientific techniques which have resulted in the position before the court today. He further recognises, helpfully and again very properly, that had further testing been undertaken at an earlier stage of the recovered samples from Miss Sindall's body, it is possible that the testing would have yielded no further information but would have destroyed the remaining sample. As things stand today, however, Mr. Pitter makes the submission that a simple point is available to him on the new DNA evidence, the power of which lies, he suggests, in its simplicity. He submits that there clearly was a sexual aspect to the murder, with a very strong inference that it was the murderer who deposited the semen recovered from Miss Sindall's body. The fresh evidence of DNA analysis shows that the semen was deposited by an unknown male and not by the appellant. Given that there is no basis for suggesting the involvement of two men in the murder, it is submitted that this fresh evidence inevitably means that the conviction is unsafe. Furthermore, it is submitted the fresh DNA evidence also bears upon the evidence now available in relation to the bite mark and in relation to the reliability of confessions made in interview. It is submitted that the bite mark evidence was of central importance to the prosecution case at trial, and a jury considering all the evidence now available might very well have reached a different conclusion. The evidence of Dr. Shepherd, it is submitted, provides a basis for challenging the admissibility of the evidence of confessions made in interview, and in any event undermines the reliability of any confession which was held to be admissible. For the respondent, Mr. Atkinson, King's Counsel, and Mr. Harris oppose the admission of the suggested fresh evidence in relation to grounds 2 and 3, but does not oppose the admission of the fresh DNA evidence. The respondent engaged a third forensic scientist, Mr. Beaumont, to review the evidence of Miss Alexander and Mr. MacDonald. Mr. Beaumont agreed with their conclusions. Recognising that it is a matter for the court, Mr. Atkinson does not seek to argue against a conclusion that the DNA evidence renders the conviction unsafe. Further, the respondent indicates that if this appeal against conviction were allowed, no application would be made for a retrial. Analysis. We are grateful to the CCRC for the care with which they considered the application made to them and for their diligence in obtaining the new evidence. By section 23(1)(c) of the 1968 Act, this court may, if we think it necessary or expedient in the interests of justice, receive any evidence which was not adduced in the trial. In considering whether to exercise that power, section 23(2) requires the court to have regard in particular to 4 matters. Quote, A, whether the evidence appears to the court to be capable of belief. B, whether it appears to the court that the evidence may afford any ground for allowing the appeal. C, whether the evidence would have been admissible in the proceedings from which the appeal lies on an issue which is the subject of the appeal. And D, whether there is a reasonable explanation for the failure to adduce the evidence in those proceedings. End of quotation. We have no doubt that the new evidence of DNA analysis satisfies each of those considerations. The statements of the forensic scientists are plainly capable of belief. They would have been admissible if they had been available at trial, and the reason why they were not before the jury at trial is that they have only recently become available as a result of scientific and technical developments. As to whether this evidence may afford a ground for allowing the appeal, we accept the submissions on behalf of the appellant. The evidence clearly did point to a sexual aspect of the attack on Miss Sindall. The inference that it was her attacker who ejaculated onto her body is very strong. There is no evidence to suggest that more than one man was involved in the murder, and no evidence to suggest that semen may have been deposited in the course of some consensual sexual activity. Strong though the circumstantial evidence against the appellant undoubtedly seemed at the time of his trial, it is now necessary to take into account the new scientific evidence pointing to someone else, the unknown man, as the attacker. As Mr. Atkinson realistically and very fairly accepts on behalf of the respondent, if the new evidence had been available in 1986, the evidence as a whole would have been regarded as insufficient even to charge the appellant. In those circumstances, we have no doubt that it is both necessary and expedient in the interests of justice to receive the evidence of the forensic scientists relating to the DNA analysis which has so recently become possible. In the light of that evidence, it is impossible to regard the appellant's conviction as safe. That conclusion is sufficient to determine the outcome of this appeal, and we can therefore take grounds 2 and 3 quite shortly. The new evidence of Professor Pretty and of Professor Shepherd satisfies 3 of the statutory considerations which we have mentioned. The bite mark evidence was thoroughly addressed by the defence at trial. Much of the evidence which Professor Pretty could now give was before this court when considering the first appeal in 2021. We respectfully agree with the reasons then given for concluding that in isolation it did not cast doubt on the safety of the conviction. 2 further points are now relied on by the appellant. First, Professor Pretty's evidence that bite mark evidence is no longer regarded as a reliable means of positive identification. And secondly, reliance is placed on a contemporaneous newspaper report as showing that prosecution counsel at trial regarded the bite mark evidence as very important. We take careful note of Professor Pretty's first point, but also note that it does not address the issue of the admissibility of bite mark evidence if it is relied upon as a circumstance forming part of a circumstantial case rather than as definitive identification evidence. In any event, in the context of a case in which the prosecution did rely on many strands of evidence, we take the view that neither of the new points is of such substance as to lead to a conclusion different from that reached by this court in 2021. The reliability of the appellant's confessions in interview was similarly considered in detail at trial and in the first appeal. At the time of the appellant's interviews, the Code of Practice under the Police and Criminal Evidence Act 1984 permitted the police to deny a suspect access to legal advice in certain circumstances. The defence were therefore able to address any suggested breaches of the code. The defence were also able to address the issue of the appellant's reliability, and the appellant himself gave evidence about why he had given differing accounts of his movement. Much of Professor Shepherd's report is, in our view, of doubtful admissibility, being on the face of it an inappropriate expression of opinion about the conduct of the police interviews. Insofar it deals with matters of psychological evidence relating to the appellant, the report does not, in our view, add anything of substance to the evidence of Dr. Wood, which was considered by this court in 2021. Again, we are not persuaded that we should reach a different conclusion. We must add that in any event, the evidence given at trial on the issues of the bite mark evidence and the reliability of confessions now has to be considered in the context of the DNA evidence as to the involvement of an unknown man. The new DNA evidence inevitably weakens each strand of the circumstantial evidence presented at trial, regardless of how strong those strands, whether individually or collectively, appeared at the time. Conclusion. For those reasons, we decline to receive as fresh evidence the statements of Professor Pretty and Professor Shepherd, and we reject grounds 2 and 3. However, we receive as fresh evidence the statements of Miss Alexander and Mr. MacDonald. In the light of that fresh evidence, we allow the appeal on ground 1. We quash the conviction. As we have noted, the respondent very properly does not seek a retrial. The appellant must therefore be released from custody. May we repeat our thanks to counsel for their assistance and for the manner in which the case has been presented.